Hello, and welcome to a discussion about estate planning. I'm Tina Srabotniak. You probably know how important it is to have a will, but have you ever wondered what happens if your will is contested? A new book looks at the cost in both money and heartache if your last wishes take your family by surprise. It's by Ian Hull, a lawyer and a specialist in estate planning, and it's called The High Price of Not Talking. Ian, let's start with that high price. What's your experience been?
Well, as a state litigator, I have seen families torn apart over the dispute in the courtroom at a level which is unimaginable. You see the emotional and financial turmoil that kind of problem solving brings, and it is both, it carries on throughout generations. It is something that is almost irreparable once you walk down that road.
You suggest something called the family meeting solution. Tell me about that.
Well, the family meeting solution is a pre-litigation step that I like to encourage people to consider because it allows the family to sit around the table, so to speak, and do some planning, not from the top down, as is typically done, but from the bottom up, letting the beneficiaries, the people that are going to enjoy the wealth that has been accumulated, let them have at least something to say in the process. And it is, in its own way, revolutionary because most people like to do their own planning in their own secretive and personal way.
Yeah, it is. And I think some people might be afraid of it because they're thinking, gosh, what a can of worms.
Absolutely. And it's something that you have to be ready for, you have to be prepared for, and you have to appreciate that it is going to open wounds and bring up issues that are going to be uncomfortable.
One of the things that causes the most acrimony, I take it, is the family cottage.
Absolutely. In my experience, the family cottage, just given the unique characteristic of it physically and emotionally, it brings about the most difficult and contentious pieces of litigation that I have run across. And in the family meeting environment, it is also one of the most difficult assets to deal with because you have to be so creative. Each person within the family who it's going to be potentially passed on to has different memories and different expectations and different abilities to buy or not buy and so forth.
It's more than a piece of real estate, isn't it?
Oh, yeah. And it's not something that we can underestimate in terms of its impact on what will happen after you die and the kind of planning that needs to go around it, both just from a tax and financial standpoint and from an emotional standpoint.
So what are the most common reasons for challenging a will?
I have sort of three answers to that. One is that too many people simply avoid estate planning at all. Probably half of the adult population statistically doesn't even have a will. So that's a bad start, and that's going to open yourself up to tremendous amount of difficulties and problems. The second is when you do get organized and create an estate plan, you don't put the expertise into the process that it needs to be brought into it. And you're not going to get the $99 will with zero problems. You're going to create your own problems if you're going to cut corners at that stage. And then the third problem is that people don't revisit their will as often as they should. And so it's not a current plan. And they may or may not understand that the impact of an event within their own family will affect how the will is distributed, how the estate assets are distributed.
You suggest signing something in your book with the grand title of a family constitution. What is that?
Well, it's a big part of the family meeting process, and it is really the wind-up to the meeting itself. And it's a document that's created within the day or so, whatever the family meeting process takes, that we sit around the table and we identify some of the principles within the family that we want to be guided by, that the family wants to be guided by, some specific solutions, identifying with some precision if we choose, example, to deal with the family cottage in particular and how we're going to deal with it. Is there going to be a shotgun approach? Is it going to be an auction? Is it going to be whatever? And everybody leaves with it signed, and they've got a plan, and they've got at least a framework to work from. A framework that has to be revisited like any good estate plan from time to time, but it's a constitution, so it's not easily changed.
Who should attend the meeting?
Well, that's a difficult question because it has to be a step-by-step process. I say to the families that want to attend at a family meeting, start with the immediate family and then build out from there. And I talk to the parent, and they typically will look to get some guidance from within the family before the meeting as well, as to whether or not we need to expand it. Do we need to consider the in-laws? Do we need to consider grandchildren? It will depend mostly on how the estate plan is generally structured and who will be affected and who won't be affected.
And where should it take place? I gather we're not talking about the kitchen table.
Well, I think it has to take place in a neutral business environment, separate from the kitchen table environment or the dining room table, because all of that brings with it its own baggage. And if you bring it out of that and you make it what it is, and this is a business meeting, and it is business issues that are going to be discussed in every respect, because it is about dealing with finances, I find it's much more effective to separate the family from their normal and classic environment.
How long does it take usually?
Well, it depends on the individual and it depends on the nature of the estate plan. But I typically tell the families that are interested in getting involved, book a day. Set aside one day at least, because we don't want to rush through this process. We don't want to miss anything, and we want to be able to have canvassed important language for the family constitution, important specifics as to how we're going to deal with some of these unique assets, and answer questions at a level that you don't want to be rushed.
It's not an informal event, is it? There are rules that have to be followed.
That's right. We set this up very carefully so that once we get to the family meeting, because it's going to be a very important moment in time for this family, we don't want to have any loose ends. We want to make sure that they understand that there is going to be an agenda, that it's got its own flexibility, but there's going to be an agenda. We're going to work toward building and creating a family constitution, and we're going to have rules, and we're going to have a decorum and a business-like environment so that we can maintain and get work done in an efficient way.
How much disclosure is expected?
Well, it's a great question, and one that every family struggles with to the certain extent, because limited disclosure, even admitting what you would admit to what your house is worth, can be a grand step for some family members and some parents. And then there are other more contentious and more problematic issues of extramarital affairs or any of the kinds of issues that would attract emotional responses within the family. Again, I encourage the family participants, starting from the parent and working down, to be prepared to fully disclose at a level that is not going to keep any secrets on the table, so that those secrets don't come back and haunt you, so to speak, once you're dealing with the distribution issues after you pass away.
What about after the meeting?
Well, I encourage the families who will come to the family meeting and the formal meeting, and I send them away with an informal process to maintain and preserve what they have done. And what the family meeting is all about is dialogue. And if you allow for the dialogue to have started to be created on issues that may have never been talked about before, I don't want to lose that momentum. And so I give people some guidance in terms of how they might want to consider organizing their own informal around the dining room table family meetings. But I also encourage them to consider and always keep in mind that it may be necessary to revisit the family meeting in a formal way so that we can cover off new issues and new developments.
What if it fails?
Well, I think that's the key to the family meeting process, because there really is no downside. If you give every family member who you think is going to be affected by your estate plan an opportunity to come and sit down with you and look you across the table, and you explain to them with clarity and with sincerity the nature of the kind of distributions you want to have result in your estate, that can be an everlasting impact and an everlasting legacy. If somebody doesn't want to come to the table, that's fine. I tell the people that are involved in the family meetings, if they're not going to come to the table, that doesn't mean we don't have the meeting, because what we'll do is we'll work toward continued disclosure to those who are there and to those who aren't there. And you will create a documentary file that is going to make it very difficult for someone who chose not to come to the meeting to somehow turn around after you've passed away as the parent and challenge it in the court environment, because the judges are going to be very reluctant to embrace a challenge when they've had lots of opportunity to consider it when it really should have been considered, and that is before your parent died.
So even a failed family conference can bulletproof your will in a way.
Absolutely. It is a cornerstone to the bulletproofing process. But I don't like to open up with a negative with the concept, but I like to make sure that people understand that it's a full circle here and that they are going to be able to get a great deal out of it, and they're also going to be able to have disclosed to, presumably and typically, at least a majority of the family, what's going on. And that can go a long way to helping the process later.
What should an estate plan accomplish?
Well, there's really three main goals of every estate plan. The first is to make sure that your assets go to the people that you want them to go to. The second one is to minimize the assets that are not going to the people that you want them to go to, like the tax department and the lawyers and the accountants. So what you want to do in an estate plan is reduce the income tax that you have to pay, reduce the legal fees and the probate fees. And lastly, you want to provide for what happens while you're alive if you become mentally incapable or disabled, that you provide some manner of protection for yourself and your family by doing a power of attorney.
What should be in a will?
Well, a will should include a couple of main components. The first is naming the people that you want to receive your assets, your beneficiaries. So that can be your family, your friends, charities. Sometimes you don't want your beneficiaries to receive a whole lump sum at one time. For example, if you've got kids, so you'll hold that money in trust till they hit some certain age, 25 or something, when they're more responsible, or at least you hope they are. And the other major component is the naming of an executor. That is the person who really collects the assets and distributes it to the beneficiaries.
What should you do before a family meeting to prepare for it?
There's a number of steps that you want to take before you've set up the meeting, the most important of which is to ensure that you have a draft estate plan completed. That will then help you decide who to invite to the meeting, where to host the meeting, who ought to be the chairperson of it, and it'll also help frame the agenda for the family meeting.
Do you need an agenda, and what should be on it?
Well, the mediator will work with you and your family lawyer to create the agenda and to set up all the things that you want to discuss during the course of the family meeting and have them flow in a logical sequence. The agenda itself will usually start with an introduction by the mediator of the players and the process, followed by some broad explanation of the estate plan. Then there'll be an introduction by the head of the family and his or her spouse if they want to make some opening remarks, and followed by a very detailed explanation of the estate plan by your family lawyer. Sometimes an agenda will also contain a discussion of the proposed powers of attorney for property and personal care, which will facilitate that kind of discussion during the course of the meeting. The ultimate goal will be the last thing on the agenda, and that is hopefully the signing of a family constitution.
What is a family meeting agreement?
The agreement sets the stage for the family meeting itself, and it identifies the neutrality of the mediator and the confidential nature of the meeting. In addition to outlining who the players are, or who the participants are at the meeting, the agreement also recognizes the parties' intention to have a consensual settlement of the estate plan.
What actually happens in the meeting?
Well, the mediator starts the meeting by introducing himself, the players, and the goals for the ultimate process. He will then provide a broad overview of the estate plan that's being proposed, and then open up for opening remarks from the head of the family or his or her spouse. The family lawyer will then step in and provide a very detailed explanation of the proposed estate plan, and he or she will answer any questions that are posed by the family members. Once the members have a good understanding of what the estate plan is all about, the mediator will then break the group up into sections, and certain family members will be going to separate rooms in order to facilitate more open discussions amongst them. The mediator will then go between the caucuses and the parents to try to identify what the real flashpoint issues are, and then possibly suggest some ways to resolve them.
How can you bulletproof your will?
Well, one of the classic challenges to a will is that the person who made it didn't have the mental capacity to make it. They didn't know what they were doing. So anything that you can do to prove that the will maker had capacity is something that's going to bulletproof the will. That is, you want to have the lawyer who's a professional take good notes that the person who's making the will is capable, is mentally capable, understands what they're doing. And sometimes we'll even ask a doctor to provide an opinion or an assessment that the person knows what they're doing.
Well, one of the easiest ways to avoid a will challenge is to make sure that your will is properly executed. Your lawyer can help you to make sure that it's signed correctly, that the witnesses have witnessed it properly, and that they've prepared the necessary affidavits to support the execution. If you later make changes to your will, you want to make sure that they too are properly signed and witnessed so that you don't otherwise invalidate the will by accident. You also want to properly document any gifts you make during your lifetime, especially if you make unequal gifts and prefer perhaps one child over another. Your lawyer can prepare the appropriate legal documents and document your capacity and your intentions so as to avoid a challenge to the gifts at some later point. You also want to carefully consider any unequal treatment of beneficiaries, because the truth is that if you prefer one child over another, that kind of gift is bound to cause problems down the road. Finally, you might be able to persuade your beneficiaries from frivolously challenging your will by including in it a clause called an inter rerum clause. What this type of clause does is it provides that if someone is given a gift in your will and later challenges your will, they'll forfeit the right to that gift.
So it's a kind of penalty for frivolous complaints.
Exactly.
Can you give me an example of some typical claims that come up?
Well, the most common claim is by a spouse who says that they weren't provided for adequately in the will, and therefore they have certain rights under our laws. The other common claim is made by a non-spouse, a dependent. For example, a child, can even be an adult child in some cases, that says that I haven't been provided for in the will, and the person who made the will was providing for my support while they were alive, and they didn't provide after death.
If a deceased person promises to pay a specific amount of money, whether for services rendered or for some other reason, and doesn't, then there is a possibility of a claim for breach of contract against his or her estate. Alternatively, if there's a promise to pay but not a specific amount, then a claim can be made for quantum meruit, seeking a reasonable compensation for work or services performed during the lifetime of the deceased.
What are some of the common reasons that wills are challenged?
Well, improper estate planning advice or a failure to consult professionals can lead to difficulties. And to avoid these kinds of situations, you'd want to speak with a qualified lawyer, accountant, tax, or planning professional who can help you avoid difficulties at the end of the day. An extended family, which is very acrimonious, can also cause problems, and what you'd want to do in that situation is to create an estate plan that's as bulletproof as possible, so that you're sort of foreseeing difficulties and dealing with them now rather than later. Undisclosed physical or mental frailties or even secrets can also cause difficulties if they're not dealt with during the lifetime of the individual. And so to the extent possible, you'd want to make sure that you plan for them now so that they don't become a problem later.
So you've got to be thinking ahead when you're making your will, don't you?
That's right.
What are some of the reasons that wills are challenged?
Well, the classic challenge is that the person didn't have the capacity, the mental ability to understand what they were doing when they made the will. That's the sort of classic challenge. But there's also other challenges, such as that somebody was coercing or unduly influencing the person to make a will in their favor.
You've been a mediator at a family conference. What's your role there?
Well, first and foremost, it's neutrality. And I have to come into these meetings, although I am retained typically and paid by the parent who has organized the meeting in that respect. But I have to maintain neutrality. Because if I can come into a meeting and facilitate and identify issues, that's the way we can create a family constitution and we can create a buy-in to the estate plan at a level that hopefully will avoid problems later.
So it should not be the same person as the one who has drawn up the will?
Absolutely not. And that's part of the unique characteristic of the family meeting. I am separate from the lawyer, the family lawyer. I am brought into the process for the sole purpose of making sure that the family has identified the issues and the family can live with the plan.
What's the role of the executor?
An executor has, in some ways, a very simple duty, and in some ways very complex. In simple terms, they just locate and collect and sell the assets, and then pay the taxes and the other debts, and then distribute the balance to the beneficiaries in accordance with the will. But it really can be an onerous job. Sometimes people consider it an honor, but anybody who's been through it knows that it's more than just an honor.
But does an executor have to be a professional then, or can you hire help?
Absolutely. I mean, the key to being an executor is being somebody who's trustworthy. And then if you need expert opinions, expert advice on accounting matters, income tax, or legal matters, you go and you hire the people that you need.
Does an executor get paid?
Courts generally accept that an executor is entitled to a fee for services rendered. Normally speaking, the rule of thumb is that an executor will be entitled to a 2.5% fee on all money that comes into an estate and a 2.5% fee on all money that's paid out of an estate. Sometimes if an executor is charged with managing a sum of money for a period of time, he or she will also be entitled to a management fee. If an executor does something above and beyond the normal administration, like conduct some litigation for the benefit of the estate, then he or she may also be entitled to what's called a special fee.
And is that ever an issue with family members who maybe think the executor is getting paid too much?
In fact, executor's fees, or the quantum of fees that an executor is entitled to, is oftentimes a very contentious and litigated point. When these kinds of matters are brought to court, the court, in determining what the appropriate amount of compensation will be, will look at such things as what it is that the executor has done for the estate, how much time has been invested in administering the estate, how complex the estate is, for instance, and the ultimate result of the administration.
So if they've done a good job or not?
That's right.
If the estate has prospered?
That's right.
What's a power of attorney?
Power of attorney is a very simple document. It just gives the authority to somebody else to deal with your finances or your personal care while you're incapable.
What problems can arise around the power of attorney?
Well, because an attorney is someone who's charged with complete control over your estate, you want to make sure that you're choosing someone who you can trust implicitly. In addition, you might want to consider providing some kind of instructions to your lawyer setting out how or when your power of attorney document is actually released so that you can avoid an improper or premature use of